you're doing well today. We're here for, believe it or not, lecture 8, so we're about halfway through in terms of lectures. Lecture numbers, maybe not lecture size. I warn you that 10 is a biggie, but hopefully it is as interesting as it is big. So we're going to talk about the time now between arrest and trial, and I'm sure you've gotten the gist of how the course is organized at this point in time. It really is kind of chronological order from about lecture 4 on, if you will, as one would move, let's say, through the justice system. In this lecture, I believe it's discussion board 3 instructions will be given as well. So let us begin then. What happens before the trial? So note, we've had arrests, we've had investigations, we gathered evidence. Now it's that time between arrest and trial. So what happens? Well, there may be an initial appearance before the judge so the charges can be read. A preliminary hearing to assess the quality of the evidence. Grand jury is sometimes employed depending on the jurisdiction. And what I'm talking about here is kind of jurisdiction dependent. So let's not be too detailed about that. The arraignment, the discovery and pretrial motions. Now, what's pertinent when we talk constitutionally at this point in time is the Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, ascertained by law, and to be informed of the nature and the cause of the accusation. And that's a big one. We have to be told what the hell it is we are being detained for. To be confronted with witnesses against him, to have compulsory process of obtaining witnesses in his favor so that we can mount defense in fairness, right? And to have assistance to counsel for his defense. So these are spelled out in the Sixth Amendment. Let's see how that plays out throughout the lecture. The initial appearance then, they're going to inform the charges. So they're going to say, hey, you're being charged with this. Probable cause determination. Is there probable cause to support the charges? We'll be informed of the constitutional rights and the right to counsel. Then there's a custody determination. Will this person be released on bail on their own recognizance, or will they be detained until the trial date? Right? So the preliminary hearing, did the alleged crime occur within the court's jurisdiction? Otherwise, if it did not, then it's got to be transferred to a court that is in the jurisdiction. Is there sufficient evidence for this to go to trial, or is it kind of just a trumped-up charge? Cases are often rejected for lack of evidence at this time. The law enforcement and the district attorney may want to prosecute, but the courts say, look, there's just really nothing to warrant bringing this to trial. It would be a waste of time. And this is also a fundamental protection that we receive. Note that we could be continuously brought to trial, brought to trial, brought to trial, brought to trial, brought to trial on no charges whatsoever, basically, or just bogus, phony charges for which there's no evidence. And the courts say you can destroy a person like this if you just continue to bring them to trial. They'll lose their job, they can't afford their attorney fees at some point, so you can essentially bankrupt someone using the system. So this is a protection we have. Look, if there's no evidence, then you got to let me go, right? Now, the grand jury is a tool to determine the nature of the evidence and if charges should be brought, again, in some jurisdictions. It's citizens drawn from the community, and it's a different, in most cases, than a regular jury where you're called to do jury service and you sit on a couple cases. This will be a long-term process, right? And that's specified by statute in the given community. But you serve on multiple cases as a grand juror. It determines if there's enough evidence for a trial. And this is called the sword and the shield. That is, the grand jury represents the power of the community to bring charges, to bring people to court, but it also operates as a shield, that is, it protects individuals. So you can see how this is fascinating in that it plays with the first dilemma, right? Individual rights versus the common good, and the grand jury, I think, is really designed to kind of sort that argument out in specific cases. Hello, Penelope. What are you doing? She's been bad, so she's a little sensitive right now. She's been doing her cord chewing. Annika, get down. Annika, stop that. It's going to be one of those days. Now, the arraignment. what do we know? Charges are read. So you can see we have a defendant sitting before a judge here, or standing before a judge. Attorney is appointed if necessary, and the defendant enters a plea, guilty, not guilty, nolo contendere, or what have you, right? Some evidence is seen, not a lot, just enough to say that this case is legit and can move forward, and may again review the issue of bail. So if bail was not set, right, at the initial appearance, then the attorney may bring up the case that we'd like bail at this point in time. Now, moving from there, we go to discovery and pretrial motions. Discovery is the process of requesting evidence that the prosecution has against one's client, against the defendant, right? The defense may be required to produce evidence as well, but ultimately what we're talking about here is evidence that might, in fact, exonerate the defendant. There may be pretrial motions that set boundaries for the trial. Let's suppose there's perhaps damaging pretrial publicity. Then this is the time that would be discussed. Let's suppose that there's a confession, but the defendant maintains that the confession was given under coercion, right? Maybe without access to an attorney or family over an extended period of time. Here's the deal. If you've got a good attorney, they make a pretrial motion to suppress that confession evidence before the trial begins, so the jury will never see it. Remember the problem. Let's suppose we have a coerced confession. The jury here's the confession, it's submitted as evidence in court, and then your defense attorney says, hey, I move that confession be struck from evidence because it was obtained illegally. And then, you know, the attorneys go up to the judge sorts it out and says, you know what, I think you're right, we're not going to allow that confession. And then the judge turns to the jury, you know how this goes down, and says, ladies and gentlemen of the jury, you must ignore that confession evidence. What does the research say? Will the jury be able to ignore that confession evidence? And we've seen, you know, research by Casson, among others, that say no, they can't. They believe they can, but they can't. And so the damage is done. This is where good attorneys really earn their money, because they prevent these, they argue against these pieces of evidence ever being shown to the jury. And that way the jury doesn't have to even be requested to forget them. So confessions. Maybe it's a witness testimony. This is a bad witness. And we say, come on, this is a bogus witness. This person can't be allowed to testify. Remember, we also looked at the research on eyewitness testimony as being especially damning. Evidence that was illegally obtained. Let's say this is evidence obtained without a search warrant, and a search warrant should have been employed. Rather than ask the jury to disregard, once again, we eliminate this evidence before the trial begins in these pretrial motions. Okay? And if there's a cause for dismissal, now's the time to bring it up. Okay. Now, let's talk about bail. We've mentioned bail a couple times here. Let's talk about bail. And bail is not get out of jail free by any means whatsoever, unless you were released on your own recognizance. But we'll get to that. Now, the 8th Amendment comes to fore here. Excessive bail shall not be required, nor shall excessive fines be imposed, nor cruel and unusual punishment inflicted. 8th Amendment's pretty short, but very important. So what is bail? Well, bail allows us to be released from prison in between the time of the arrest and the trial. So over 500,000 people in jail in the United States right now, over 500,000 people in jail are awaiting trial. And this gives you an idea why bail is so damn important, because these are people who are being held. They can't, but they've not been convicted. So they're being detained, awaiting trial, but there's never been an adjudication of guilt or not guilty, all right? So they're essentially being detained. Why? Well, that's the big question. The purpose is to deter flight. That is to keep people from running away and not facing their day in court, so to speak. Now, there's guidelines against excessive bail, but then we ask a question, and when you move into discussion board 3, I'm going to float some ideas at you. What is excessive? Okay. Excessive can mean very different things to very different people depending on their income level. Jeff Bezos, what is worth, who knows, what, 50 to 150 billion dollars? I don't think there's any bail amount that Jeff Bezos can't afford. So it's excessive bail in Bezos's case. If we look at it from his ability to pay, there really isn't such a thing as excessive bail. But if you look at me, and you guys know what I make because it's a matter of public record. So if I make, you know, $56,000 a year, what is excessive bail for me? Well, you can see that my number of what might be excessive is far lower, but that's not necessarily how it's calculated. Regardless, what we see is wealthy defendants have an advantage. If you're wealthy, you're much better able to make bail, pay bail than not. Now, factors in bail decisions, the flight risk. So low-risk offenders often are released on their own recognizance, right? And that's released on own recognizance, ROR. Note, when you get a speeding ticket, not that any of you ever have, but if you get a speeding ticket, you get pulled over, and they say, when they finish filling out the ticket, they say, please sign below, and when you sign below, it's not an admission of guilt, it's simply a promise that you will appear or pay the fine, whichever way that you choose, depending on the nature of the offense. What you're doing is your signature releases you on your own recognizance. It's a promise to appear, so it's an equivalent of your signature being bail, if you will, right? Very few who are released on their own recognizance fail to appear. And this is an interesting statistic because then we ask the question, well, how many people do actually fail to appear under these circumstances? Now, flight risk is one kind of calculation. So the judge is going to say, well, does this person get bail? Well, what's the likelihood that they will flee the country, flee the city, not show up, right? The other possibility that bail might not be allowed is for preventative detention. That this person, we have reason to believe that this person is a clear and present danger to the community, to themselves, so they will be held in preventive detention. Charles Manson didn't get bail. Charles Manson was never going to get bail. Charles Manson was one scary dude. These crimes were heinous, and bail was just not going to be entertained in Manson's case, right? So bail may not be granted if safety of any other person or the community is in danger. So put that, you know, in your notes. Make sure to understand that bail can be denied, right? But it's going to be on the basis of preventative detention and or extreme flight risk. Again, we get the first dilemma, individual right versus common good. That is, but I have the right to bail, right? Because individual rights dictate this. But we say, yeah, but damn it, you're pretty dangerous. And I don't think we should allow you to go. We got to protect people. We got to, you know, protect the common good. And if while you are arrested, you are threatening all the witnesses against you, or you said, you know, I'm going to finish the job, etc., that information might, in fact, then tilt the court to say, look, this guy's already made threats that he's going to harm people. We're going to keep him in. Now, the problem with this is the predictions are notoriously inaccurate. So anytime that we try to make a prediction about an individual case, right, we could very well be wrong. The better judgments are what are called actuarial judgments when we make predictions based on some kind of classification that you're a member of a given group, right? So actuarial judgments are what insurance companies do. And insurance companies are very good at determining risk, otherwise they'd go out of business, right? But when we look at individual probabilities, it becomes much shakier, okay? So predicting flight, what do we know? 17% of 2,200 felons were rearrested within 90 days. These are people who are felons that previously convicted. They have felony records. 17% were rearrested within 90 days. Note, this includes a new crime and failure to appear, both. So we have to consider then this failure to appear is a legitimate consideration. But here's the deal. Who is this guy? This is one scary looking guy. Yeah, this is Dog, the bounty hunter. Let's just talk a little bit about how bail works, right? So bail works. Let's say that I get arrested for some fantastic crime, big crime, and they say, Mark, your bail is $1 million. And I say, I don't have $1 million. And they'll say, well, you got to post $1 million. You got to sign this note that says, here's $1 million of your assets that the court can have, that $1 million, if you fail to appear. Now notice, if I'm rich, this isn't a big deal. I say, yeah, sure, check my savings account out, or check my, check this out. Yeah, I'm worth, $10 million. I can guarantee the $1 million, and the court says, cool, if you don't appear, boom, we're going to take your $1 million. If you do appear, then you're cool. You get to keep your $1 million, right? So it really is on the basis of whether I appear or not. But I'm not rich, so they say, Mark, your bail is $1 million, and I'm like, I don't have $1 million, and they say, well, tough shit for you, and I say, well, that's really nice, and they say, but if you go across the street from the courthouse, and that's where these businesses usually are, go across the street from the courthouse to that bail bondsman, right? The bail bondsman will put up your $1 million bail for a fee. And what that means is I'm going to go to the bail bondsman. Well, I can't because I'm not out, right? But my people are going to go to the bail bondsman. They say, we need bail for Mark. His bail's set at $1 million. And the bail bonds company says, okay, that'll cost you $100,000. They charge 10%. So what the bail bonds company is doing is they're putting up a guarantee of $1 million if I don't show up. So if I don't show up, it's going to cost them $1 million. But they charge me $100,000. If I show up to court as I'm supposed to, they keep the $100,000 regardless. The $100,000 that they took from me is the price of them posting bail on my behalf. Now here's the deal. I'm out $100,000. Notice, if I was wealthy, I could have posted my own bail without a bail bondsman, and I'm out no money. So it's the poor who interact with the bail bonds companies who are being charged because essentially they don't have the money for bail. And it's non-refundable. I mean, now what if I don't show up? What if I say, well, screw that, I'm not going to show up to court because it doesn't look good for me. I'm going to take off. Well, then the bail bonds company is going to call DOG or any of their bounty hunters, and they're going to say, look, this guy skipped bail. You go get him, and you drag his ass to court so that we don't have to pay that $1 million to the court. And the bail, the bounty hunters are going to leave no stone unturned. They're going to find my ass, and they're going to drag my ass kicking and screaming into court to protect the investment of the bail bonds company. Okay? And that's why DOG's such a badass, and that's why he's so mean. And the law really favors bounty hunters. These guys can carry weapons, licensing not necessary. They can kick down your door. Search warrants aren't necessary, right? So they've got a whole host of rights to do business that most don't. So you don't want to mess with the bond companies because they're tough sons of bitches, right? And they will come after people. Now, notice, a while back, DOG, of course, probably the most famous bounty hunter, got in trouble because he pursued someone who jumped bail down into Mexico. And Mexico says, no, we don't allow that down here, right? So that, in fact, got DOG into some big legal trouble. But let's face it, bail bondsmen are free to go from state to state, community to community within the United States. They can do just basically anything they need to find you, recapture you, and present you to the court. That's their business, right? Now, what do we know about reoffenders? Well, they're more likely to live alone, okay, sure, have originally committed a property crime, and this is correlational evidence. You know, when you say, okay, so if you look at the correlations, more likely to have committed a property crime, but what does that mean? What is the mechanism there? And that kind of, we're kind of left high and dry considering that. They have a history of failing to appear. Isn't that something? Someone who didn't appear has a history of failing to appear. 2 rules. I'm gonna give you my 2 basic rules of psychology. So file these under Mark's rules. Number 1, you can't change people, which isn't pertinent to the situation, but you can't change people. People can change. I'm not saying that. People can change if they want to change, but you can't set out to change people and change people. That's rule number one. Rule number two, the rule that's pertinent in this case, is the best predictor of future behavior is past behavior. Let me repeat that. The best predictor of future behavior, all else being equal, and that's a giant caveat, is past behavior. So if you want to kind of try and figure out what someone's going to do in the future, it's best, safest, most probabilistically supported to look at their past behavior. Now, you know, the caveat is, what are there situational differences as we're talking the same domain, etc. But two rules for psychology. So, from me. Demonstrate signs that police officers noted at time of arrest, and I already gave you an example of this. If they're threatening witnesses or people, they might say. Now, why does this matter? Well, pretrial release affects the trial outcome. Defendants who stay in jail, what do we know? Well, they're more likely to be found guilty. And we can look at the research there. That's pretty straightforward. Hey, Hannah. What are you doing, sweetie? You want to say hello to everybody? Hannah. Yeah, thank you for saying that. Come on up. Come on up and lay down. They receive harsher sentences. Again, something that we can demonstrate empirically, right? They're less likely to receive needed medical treatments. And this is something I've added this semester that, in fact, I've got a video for you to watch that I think explains this extremely well. But if you're in jail in pre-trial detention, right, who's taking care of your needs? Do you think that the community, the county, the city, jail actually care? Maybe not so much. Now, also we have to consider this, that it's harder to prepare your defense in jail, right? You have less time with lawyers. If you're in jail, right, your lawyer comes and visits you when they feel like it. And you know, for a lot of us, when we want to make shit happen, right, we go pound on people's doors. We go bother them, so to speak. We continue to go to them and say, hey, how's my case going? How's my case going? If you're in jail, you don't get to do that. Your attorney's going to show up when they show up, and they're going to, you know, so you lose a lot of control, at least psychologically, sense of control over your outcomes, not to mention the actual occurrence. You have less access to witnesses and records. That stuff doesn't exist in your cell, right? So you're not able to use or study that information to help assist with your defense. You can lose your job. What's going to happen at Ohio State, right? If I'm arrested and now I'm put in jail, let's say I'm arrested tomorrow and I'm put in jail and they don't allow me out on bail. Well, who's teaching this course? Is Ohio State going to say, well, oh, Mark's in jail, so we'll just, I don't know, I guess refund everybody's tuition for the course? And those people who are going to graduate kind of screwed on that shit, you know? So, well, no, you can lose your job. And if I lose my job, then what little money I had that I might use to pay my attorney is missing. I have no more income, and that's not going to work too well, right? Is this disturbing you, Hannah? You look kind of worried about this. Nobody's going to arrest you. You've done nothing wrong, all right? It corrodes family and community ties. So you can see that there's a lot of downsides to not getting bail. Now, are bail practices discriminatory? Well, as we stated, clearly an advantage to the wealthy. If you can post your own bond, then you're out no money, right, as long as you appear. If you can't post your own bond and you go through a bail bondsman, you are going to then, poor defendants, be out at least 10%. And many innocent, and let's back off because it's not a legal term, many not guilty, right, people spend a fair amount of time in jail because they can't afford bail. So they just have to wait. And if the court system is slow, they have to wait that much longer. It's not like, well, hey, I'm ready to go to court, so let's go. You know, the courts might be backed up, and they say, well, yeah, you don't have bail, so you can just sit in the cell for 6 weeks, 6 months, until we're ready to put your court on the docket, right? 2 surveys. Of 1,000 people jailed in Philadelphia for an average of 33 days, 67 were acquittals, no jail time. So think about this, right? We got 2/3 of that 1,000 in this sample, right, who served an average of 33 days in jail and were never found guilty of anything. So pretrial detention is essentially, it could be reframed as a punishment. You're doing time, although You've not been convicted of any crime. And then after that 33 days, you know, they come out and say, well, it's time for you to go. And you say, well, what you know, well, you've been found not guilty, so get the hell out, right? Now, if we look at another sample, 114,000 nationwide, the figure was 73%. So let's say that 2/3 to 3/4, right, of the people who've been in jail, pretrial detention, are found not guilty. So odds are the people that we have in pretrial detention, odds are that they will be found not guilty. They will be acquitted of that crime, released somehow. How does that sit with you? I mean, is this just the cost of doing business? Or is that something that we should be concerned about? And that's where we're going to go. So, I got one more piece of research here that I just find freaking amazing. And are bail assignment practices subject to other situational factors? Now remember, why might bail be denied or why might be increased? Because I present a flight risk or I present a danger to the community. But are there other reasons why bail differences might be observed? I want to talk a little bit about terror management theory. So let's get a cemetery up here, because a cemetery would activate thoughts of death. It's just a natural association, cemetery, death. The interesting thing of terror management theory, right, which started in the 1980s, kind of growing out of social psychology, but also clinical psychology, kind of a blend of the two, was that people have what's known as existential anxiety. When they're reminded of their own death or the death of others, which reminds them of their own death, it causes anxiety. And it's anxiety about the end of my existence. It's problematic because we don't know what's going to happen when we die. Now, that's one of the reasons religion comes to the rescue, and almost every religion tells us this is what happens when you die, in an effort to diminish our existential anxiety, right? Because we can't live that way. We can't live with this constant threat of death anxiety over us. So, as social psychology became more and more interested in this, clinical psychology was kind of done with it pretty quickly. Social psychology says, well, what causes people to suffer this existential anxiety? And it's combined with a lot of priming studies. So a lot of manipulations were done in the laboratory to study how people diminish their existential anxiety. One is connecting with your culture. So to the extent that you connect with your culture, or your family is another way to look at this, what's happening is you say, I might die, but my culture will continue, or I might die, but my family will carry on the bloodline. So it tends to diminish our existential anxiety because we're connected to something bigger. And by being connected to something bigger, our death becomes less threatening. Right? Well, a typical way to do this, to make people in the laboratory consider their death, you randomly assign people to one of two conditions. Now, the one condition you say, hey, and this is the existential, this is the terror-invoking manipulation. You say, what happens to your body physically as you die? And then people then write a paragraph describing the worms crawl in, the worms crawl out, the worms play pinochle on your snout. Yes, this is a childhood poem that I remember for whatever reason, but your body deteriorates. Now, the control condition is you say, hey, what happens when you digest a hamburger? So notice, it's still focusing on bodily sensations, but not connected to death. And then, that's the independent variable, that's the manipulation. Then the dependent variable is of any, you know, dozens of forms, depending on the number of studies. There's probably 300-400 existential anxiety studies out there as we speak. In this case, what do? They do this manipulation to judges. So instead of having college students as participants, they got honest-to-God judges as participants. They subject them to the terror management manipulation, right? Cause existential anxiety in half the judges, leave the other half. So what happened? Yeah, the judges posted higher bail amounts for the prostitutes on the basis of being manipulated into existential anxiety. Fascinating study. I love this study because all our studies are about college students, right, as participants. Like 90–95% of social psychological studies involve college freshmen and sophomores, according to Sears back in the 1960s. In this case, what we see is professional judges who are all about setting bail. And yet a simple manipulation of terror management causes them to, in fact, change their bail decisions from what they normally would be. Fascinating, right? So a lot of the world happens unbeknownst to us. And see, judges can't correct for this potential mistake because they're not aware it happened. So if a judge is on the way to court and they almost get in an auto accident that threatens their thoughts of their existence, they may come in and actually be more harsh towards people who violate our cultural norms, i.e. prostitutes. Because remember, you want to get tight with your culture because your culture persists. It protects you from the thought of your own death. So that came to us from Lion et al. Now, I got a video here, and I'm not going to show the video. This is a TED Talks video, How Jails Extort the Poor. This video is incredible. It's absolutely amazing, and it's what you'll see is a researcher who's potentially arrested. They're threatened with arrest because of their ethnicity, right? And they're deemed to be a threat when they weren't. And this caused them to then start to investigate the judicial system as part of what the research they were already doing. And it talks a lot about the revolving door kind of bail system. So please watch this video. Your assignment is based on this, right? So discussion board 3, and that's a live link, so you can just click on that link and you can go there. So in fact, I would just pause this at this point in time and go ahead and watch it, right? Now, here's discussion board 3, improving our pretrial detention system, and you really need to watch the video to understand where this is coming from. Okay. What is excessive bail? Well, that's a rhetorical question. You don't need to necessarily answer that, right? But certainly consider it. Please answer the following. Then number 1, should bail be proportionate to one's income or wealth, or should bail be fixed by crime type? Now, currently, bail is basically by crime type. This type of crime presents this range of bail amounts, right? But again, Bezos can afford any level of bail, right, basically, that the court might assign according to crime type, whereas you and I might not be able to afford that bail if the bail is based on crime type. If the idea is to keep us from skipping, it's motivating us to actually show up in court. Doesn't it make sense that someone who's super wealthy needs to have a higher bail amount, perhaps, and someone who's poor doesn't need to have as high a bail amount because the impact is just as significant with a smaller amount? I want you to consider that proposition and kind of talk your way through it, right? So should it be proportionate? Let's just imagine maybe that there's a different system that's possible. Now, oh, I'm sorry. Now, what about flight risk? Well, is flight risk equal among the wealthy and the poor? Let's face it, I'm not probably going to be capable of fleeing to Europe to avoid my prosecution, right? That's unlikely. And a lot of times if you're going to be, they'll ask you to remand your passport so you can't get out of the country anyway. But let's suppose that I'm very poor and I live in an inner city. Exactly where am I going to flee to? And what exactly am I attempting to avoid, right? So again, let's consider that. Is flight risk equal among the wealthy and the poor? And you know, a short paragraph thinking your way through that. And then finally, what is one way that we can improve the bail system to minimize pretrial detention? And this goes back to the video because the video describes in very, very graphic terms what it means to be detained in pretrial, and I've given you the statistics there as well. And for your suggestion, you know I'm going to go here. What are 2 pros and 1 con to go with your improvement idea? So I'm asking you, hey, what do you think we can do to improve this situation? What are 2 benefits that are attached to your suggestion, but what is a potential con? Because I think the most important thing is, hey, this is my idea, right? We present my idea, and now that this is my idea, I'm going to suspend my ego for a minute and say, this could be what's wrong with my idea, right? So let's make that argument there. Questions? All right, so that's discussion board 3. It's no response is necessary, so this is just a straight up post answering these questions. And if you would please number the questions in the discussion board as you write them down. It'll make it easier for the course assistant or Logan or I to grade it. So we really appreciate that. Okay. I don't know who's set to grade it. So let us return to an idea that I talked about early in this lecture. And this is the issue of criminal discovery. Now, criminal discovery is all about evidence, and especially the evidence prosecution holds. Now, what I've done is I've stolen this. Not really. I've asked if I could use it, and I was told yes. Note that if you're a lawyer or you're a paralegal in Ohio, then you have to take what's called continuing legal education. You have to attend sessions, seminars, CLEs, right? This is an honest-to-God CLE that was presented at the Ohio State Bar, right, over there off of 5th Street, 5th and Riverside, where the bar. Now, how did I get this? Well, this was actually written by my wife as a paralegal at a downtown law firm when she was working at a law firm on behalf of attorney Brian Dickerson. So Dickerson then takes this presentation, this PowerPoint presentation, this is the presentation, and gives this presentation at the bar as a CLE. The attorneys, hey, Quincy, what are you doing, buddy? We have the Black Cat contingent visiting us today. So this is an honest gut CLE, so I'm just going to do the CLE. I'm going to present it as Dickerson did at the bar to give you an idea. And it works on a couple layers because it's going to tell us very completely about the process of discovery. But it also, if you listen to the tone, because Dickerson is speaking as a defense attorney, so pay careful attention to the way this was written, because Dickerson and my wife did a very careful job in developing this. Right. So here we go. Criminal discovery, an example of perceptions in the legal system. So, a criminal trial by ambush should be a thing of the past if you're doing your job correctly. Whether practicing before a state or federal court, there are a number of ways to get the evidence you need to prepare your defense. What's the defense attorney's role? First, learn what the government knows. Second, learn something the government doesn't know. Now, let's visit the prosecutor's role. First and foremost, the prosecutor is your adversary. Second, the prosecutor is also an agent of truth and justice. With this in mind, you're likely going to have to fight for every piece of evidence to which you're entitled. So what is that evidence? What can you obtain? Any statement your client made, the client's prior criminal record, documents and other physical evidence used by the government at trial, reports of any examinations or tests, expert witness summaries. Right? Now, let's take a look at a couple of these in more detail. Your client's statement is probably the most important item you can receive and includes grand jury testimony. So if they were called before the grand jury, what is their honest-to-God testimony? Are there any signed statements by your client? The communication between your client and any government official. So video of the drunk driving arrest and subsequent sobriety test, right? Audio of the interrogation, etc. This is all should be made available to you to assist in preparing your defense. Why is it important? Well, the contents of the statement is going to set a tone, right, for your entire defense. It lets you see if your client convicted himself. Did they make a full confession? Did your client remain silent? What did they do? It may allow room for you to plea bargain or not, right? It may decide if your client can take the stand or if your client should not be questioned on the stand in the court. And it shows any remaining affirmative defenses that might exist. So the client's prior record, well, Usually the government will simply provide the FBI's rap sheet, just the criminal history of the client. The rap sheet will obviously play a part in determining if your client can testify in his or her own defense, right? Bottom line, the longer the rap sheet, the more harsh the government cross-examination can be, right? So you might not want to put your client on the stand if they have an extensive rap sheet that can lead a very long interview in front of the jury, right? Now, for most of us, we have no rap sheet, so that would not apply. But now, other government evidence. You may examine documents and other items that belong to your client or obtained with a search warrant. So anything that, you know, that was obtained is fair game for you to look at. Look at everything obtained by the government. The exculpatory items are required to be produced, but likely going to be buried beneath useless items. Now, what does exculpatory mean? Exculpatory says, hey, the government, in preparing their case against you, got this piece of evidence which tends to refute their case. It tends to exculpate you, that is, demonstrate your lack of guilt. Right? And you can see why the government would want to hide that kind of evidence. The government must produce the exculpatory evidence, and this is covered by Brady versus Maryland. What does Brady cover? And notice, here what we're talking about is stare decisis, previous decisions guide current procedures. So, evidence that may show a defendant's innocence, which there's reasonable probability the admission of such evidence would lead to an acquittal. So the government's hanging on to something that would tend to demonstrate your innocence, especially to the extent that it could actually lead to an acquittal. It must be produced, right? There's obviously going to be a difference between the prosecution and the defense's definition of Brady material. Right? The defense is probably going to overstate their case, and the prosecution would understate the case on how valuable this evidence is. Neutral, irrelevant, speculative, inculpatory, guilt-demonstrating evidence is, and inadmissible evidence is not considered Brady material. So it really is the exculpatory evidence. Conclusion, you may never know the ace card the prosecutor's holding, but with some creativity in the discovery process, you should be able to go to trial with some parity to the prosecution. Okay. And I like to think about Dickerson delivering this. Dickerson was a former minor league baseball player. He's a tough guy. He's a hard-ass competitor. If I needed an attorney, if I was going to court, I'd want Dickerson because he's just a hard ass, right? And he's going to fight the good fight. He's adversarial, and he's going to do everything he can to win that case because winning is everything to him, right? But this is an adversarial system, and you can see throughout this presentation, which is about Brady material, it's really saying that the prosecution is more than willing to play down and dirty, and if you're going to have a chance, you better be on your game. You better bring your A game. And you can see why a lot of former athletes are interested in the law because of that competitive nature, and there's probably no more competitive environment than, let's say, the courtroom in this regard. So about discovery, what could possibly go wrong? And I had a boss who always used to say this, Pete Mulevelt was, hey Mark, what could possibly go wrong? And I'm like, oh my God, I wish you wouldn't say that because now you totally jinxed it. Well, these guys, the Duke University lacrosse team, was thought to have hired prostitutes for a party and then raped those prostitutes. Well, we see a community of color where Duke University is located, and the general perception or stereotype is, oh, look at all these wealthy white kids who go to Duke and you know, they just thumb their noses at the people of color in the surrounding community. Right, these entitled bastards, so to speak. So when this case came, there was a huge community uproar to, in fact, prosecute the Duke lacrosse team, hold them accountable to the fullest extent of the law. Mike Nifong was the district attorney at this time. Well, and as an aside, there were like a letter signed by 89 professors at Duke condemning the members of the lacrosse team. And I mean, that came out in the first week this happened. And they knew nothing. They assumed, they operated on the stereotype that these kids did this. Well, what happened? The prostitute, one of the prostitutes was, subjected to the rape investigation, and the rape kit was obtained, and Nifong, gets the report from the forensic scientist, and the forensic scientist says, no, there's none of these guys' DNA. This has nothing to do with any of the lacrosse team members. So there is no basis for a case of rape. And Nifong told the forensic scientist, well, I want that report, and you're to say nothing about it to anybody. So Nifong suppressed the report. He just buried it in one of his desk drawers. Well, notice, this is Brady material, because what it's saying is there is no DNA match between the defendants and what was found on the victim. This is entirely exculpatory evidence. Nifong hid it so he could continue on with his prosecution. Well, this discovered, and Nifong was then convicted of concealing this evidence. And of course, the ex-DA, because he lost his job as district attorney, he does time. He does time for his crime. How long did Nifong spend in jail for his crime? Any guesses? Whole day. One whole day. Yeah. And notice, when we go back to one of the assignments earlier in the course, I said, should agents of the law suffer harsher penalties? And one of the reasons that many of us ask that question, should they receive harsher penalties? Because a lot of times agents of the law seem to face absurdly light penalties. A single day for this. He destroyed these guys' lives with his overzealous prosecution and is hiding the exculpatory evidence. So, is everyone going to agree what's exculpatory? Probably not. Do pre-existing cognitions affect one's perception of evidence? And this is a straight-up social cognition, social psychological question. To what extent do our pre-existing notions affect the way we interpret relatively ambiguous evidence? And there's a whole host of literature on that that's available to you guys who are interested. Now, we're going to shift gears a little bit. We're going to talk plea bargaining, and Let's Make a Deal. And there's the illustrious Monty Hall of the original Let's Make a Deal days. And Let's Make a Deal is a great show. You dress up in some kind of costume, and if you're wild enough in the audience, they pick you, you come up, and they say, hey, look at what we got. Do you want what's in this box, or do you want what's behind the curtain? And I say, I want behind the curtain. And they say, and then they show me first, whichever is better. They would show me either the box or the curtain in whatever order. And then once I got the stuff in the curtain, it's like, maybe it's a weight set, right? So, and I look at this weight set, and, I'm going, and then they say, okay, so, hey, you can keep what you just won, or you can trade it for what's behind this other box here. What do you want to do? Or maybe I'll give you $500. So people are always making a deal, and that's the whole nature of the show. And notice the show has been restored to all its glory and currently on daytime TV. So plea bargaining, let's make a deal. That's it. Defendant cooperates with the DA in return for some concession. And the concession can be a lighter sentence, perhaps. It can be a reduced number of charges, and that's typically the way it goes down. Two ways to bargain that. Now, I have two plea bargainers here. Pictures showed up. We have a portrait of James Earl Ray, and then we have a picture of someone with a well-trimmed beard in a sport coat, handcuffed, being moved about. Who are these people? Who is James Earl Ray? Anyone? He was the man that assassinated Dr. Martin Luther King. So this man took a .30-06 hunting rifle from a hotel across from the hotel King was at. King came out on the balcony, and James Earl Ray shot him dead with that rifle. James Earl Ray, it was obvious who had committed the crime. He pled guilty to murder to avoid the death penalty, thus receiving life imprisonment. The other guy, who's that? I'm going to leave that for a little while because we're going to talk about him in a later lecture. Most estimates, though, is that how often does plea bargaining occur? About 80 to 85% of cases are dispensed through plea bargaining. And the two types that I alluded to just a moment ago, charge bargaining. So we drop some charges. We say, well, you know, we're going to charge you with first-degree murder, we're going to charge you with all these crimes, but if you cooperate, if you admit guilt to these lesser charges, we'll drop the higher charges. Charge bargaining. Now, problem with this, and where the district attorney kind of still maintains their edge since they bring charges, is district attorneys will bring 10 charges against you, everything they can conceivably charge you for, with the intent of bargaining and really just charging you with two things. So they overinflate the number of charges, knowing that they'll give some of those away as part of the bargaining process. Now, sentencing bargaining, on the other hand, is reducing the sentence. So we're going to talk to the judge and ask for a reduction in the sentence. So where this might normally carry 10 years, right, what we're going to do is ask the judge to give you 5. Okay? So the judge usually follows the recommendation in these, but doesn't have to. So it's still up to the judge ultimately. Now, what is plea bargaining? DAs, why do district attorneys plea bargain? Well, they can dispose of cases with weak evidence. If my evidence isn't that good and I know it's not that good, then I might see if I can get the defendant to cop a plea. At least they'll be found they'll admit to guilt for something, right? Plea bargaining, often getting one defendant to testify against another. If you testify against your buddy, right, then in fact we won't charge you, or we'll ask for leniency from the judge based on your cooperation. But ultimately, I think it's to expedite the cases through a very overcrowded system. So 80 to 85% of cases are plea bargain. This means they didn't clog up the courts. This is done really outside of the courtroom. Strangely enough, maintain a cordial working relationship with defense attorneys. And I never, you know, I always thought, wow, that's really a strange statement. But when I was working with the law firm that my wife worked at, you know, they love to go out and drink. So we would go out, you know, and drink sometimes with them. And it was funny to sit at the table full of attorneys, right, and other employees from the law firm, and have district attorneys come by and have a drink, or have judges come by and have a drink. It really is kind of a big club when you get right down to it. So a lot of the combativeness is in the court, but a certain level of cordiality outside the court. It surprised me. So avoid unpopular trials. And let's say you've got a trial that was a mercy killing. You've got an 85-year-old woman who helped her 89-year-old husband commit suicide to escape the ravages and the pain of cancer, terminal cancer. You know, well, it was illegal to assist the suicide, but does the district attorney really want to go there? Do they want to slap on the front page of the paper, district attorney seeks first-degree murder charges against 86-year-old grandmother? Probably not, right? So maybe it's better to plea bargain some of those out if they look like they're going to be unpopular. So what are some pros? And let's do the pro and con thing, because that is what we're frickin' about, is critical thinking. Advocates claim admission of guilt is the first step towards rehabilitation. I will support this. In our research lab, in the Tetlock lab, what did we do? We researched punishment, and it took me down a path of also researching forgiveness, because I wanted to manipulate both those motivations in the laboratory. What I discovered, one thing I discovered, is every major religion basically on the planet says if you want to be forgiven, you must first admit guilt. Right? That's just kind of a core component. Pro, it relieves a backlog of cases. This is a rational response to a real problem. We just can't process all the cases in the court system in some kind of timely fashion. So let's move them through via plea bargain. It reaches prompt and final outcomes. There's no appeal on a plea. You plea, that's done. You sign the plea, you accepted it, you're good to go. Appeals don't occur after that. Others benefit too. If someone cops a plea, right, even to a lesser crime, the police are freed up. They don't have to testify in court, so it spreads police resources more evenly. Maybe a victim really doesn't want to relive the crime in court. That is, let's suppose someone has been raped, and the victim now is faced with this idea of the scrutiny in the court, and we talked about how that can go down and how unpleasant that might be. Maybe the victim and the district attorney say, look, you know, if we go for the rape charge, we might get 10 to 20 years if we win. If we go for this aggravated assault charge, we can get 6 years, but you're not going to have to testify because they copped a plea. You can see where that might be. Or if children are involved and we don't want to bring them into the noxious environment of the courtroom, right? The defendant cooperation, as we suggested, might facilitate the prosecution of others. List of cons, it's fair, right? Critics claim, hey, results in improper sentences. That is, people are not getting sentenced for the crime that they committed. They're getting sentenced to a lesser crime, right? So Paris Hilton wants to drunk drive for the 90th time, and she's slapped on the wrist once again. Is justice being done in that situation, right? It encourages defendants to surrender their constitutional rights. When you plea bargain, you're saying, hey, I don't want a trial. I don't want to confront my witnesses. I am just saying I'm guilty, right? Prosecutor exerts too much power, and we talked about that in terms of charge bargaining and overcharging, right? This is done in private. Now note, one of the concepts of doing court trials is the public is allowed to come to a trial. That is, we can all participate in this process and witness it. It's a public spectacle, if you will. Plea bargains are done on the down low. They're done in the back room so that we don't have the same view of what's occurred. Innocent defendants may feel coerced to plead. And think about this. This can be problematic if they say, look, Mark, here's the deal. We got pretty good evidence against you, and juries are really kind of hot under the collar to convict people for this crime. It's a good chance you'll get 20 years if you're convicted of this crime. Now, if you're willing to plea, we'll charge you with this crime. If you're willing to plead to this crime, then we're going to talk to the judge, and it's a guarantee basically that you're going to get 2 years. And it's like, okay, so do I want to roll the dice on 20 years, or do I want to take the sure thing of 2 years? And note that that can be somewhat coercive. You know, we say, oh, no, I would never do that. But until we're in that situation, it's hard to know exactly what we would do. Yeah. Okay, let's talk pretrial publicity. We're going to shift gears. We're going to close this lecture out. Right, so a couple more slides. We'll talk pretrial publicity. What does this mean? Well, I don't know how many of you, I'm a Californian, so although I was in Washington at the time, O.J. Simpson was thought to have perhaps been responsible for the death of Nicole Brown Simpson and Ronald Goldberg. What do we see? Well, we saw the Bronco chase. So we see this low-speed chase down the freeway with Cowling and O.J. Simpson in the Bronco, really leading this parade of law enforcement from all over Southern California until they finally pull over and O.J. Simpson surrenders. This was on the news live, and then every newspaper is handling this. Everyone's talking about O.J. long before the trial is ever set to begin. Is it possible that O.J. is going to get a fair trial, or have all the jurors already made up, all the potential jurors already made up their mind as to his guilt or innocence, right? So pretrial publicity carries with it the threat of not receiving a fair trial. Now, this guy had a lot of pretrial publicity as well. This is post arrest for him because he actually tried to flee. Who is this? Scott Peterson. He was thought to have murdered his wife, Lacey Peterson, and the unborn child, right? A tremendous amount of publicity. Another California case. This is actually Scott Peterson. He was stopped at the Mexican border. Interestingly, he was trying to flee prosecution. Excuse me. He had $20,000 in cash, a bottle of brown hair dye, so you can see the change in his hair color, and a big bottle of Viagra. So I don't know what his plans were down in Mexico, but that was where he was going. Here's another high-profile case, perhaps illegal stock trading by Martha Stewart. and actually ended up in prison for this, federal prison for 6 months, right? Interesting how you can be a congressperson and engage in all kinds of illegal stock trading and nothing happens, but if you're a celebrity, you know, doing a cooking and home show, I guess you're fair game. Okay, here's another guy. We know who this is. This is another Peterson. Maybe it's a condemnation of the Peterson name here in this lecture. And this is Drew Peterson. Drew Peterson was arrested for the disappearance of his third wife. But interestingly, his second wife died of drowning in his garage in a wash bucket with about a ½ inch of water. And people were interested when his third wife disappeared. They said, well, what happened with the third wife? But the second wife, but that crime was investigated. But the problem with Drew Peterson is Drew Peterson was a police sergeant, and he essentially led the investigation of his own second wife's death. So, and he's out of the picture now. He was convicted. But these are huge cases with a tremendous amount of publicity before they ever go to trial. So that's our issue. Trial cases clash between the right to a speedy, unbiased trial and freedom of speech, right? And the media does have the right to report on what they find. But the problem is that people who consume it then might become potentially biased jurors. So it may be more of an issue in small areas with aggressive local media, right, where the jurors are going to be drawn from a small community and the community has a local vigorous newspaper. It might actually be more dangerous in those instances than in big cities like the cases that I've shown you, either in the Bay Area in California or Southern California. Pretrial publicity raises two questions. Does publicity threaten the fairness of the trial? Number one. And if it does threaten the fairness, what the hell can we do about it, right? It's one thing to say, oh my God, you know. Now, I'm going to come at this from a much different perspective. I'm going to put my social psychological hat on. It never goes far, right? And I want to talk about perception and how we are influenced, how we process information. So, how mental systems believe. We're going to take some advice from Dan Gilbert based on his dozens of years of research in social cognition. Gilbert starts with the idea that there's a root, the roots of perception is seeing as believing, and we know that's a cliche, seeing as believing, but let's face it, it is a really good picture of how we operate. If we see it, we tend to believe it. Because think about if you wake up some morning and you can no longer believe anything you see, then really that is kind of a definition. It's included in the idea of a psychotic episode. If I can't believe what it is I'm seeing the world and it's not reality, it's something else, then this becomes a mental health issue at that point. So we have to believe what we see, at least first and foremost. So the way this goes is I see it, right? I process it, and then I process it further so I understand it. And that implies acceptance. Now, if I want to unaccept it, if I want to disbelieve it, that's a second step. So what we're talking about here is belief is automatic. Disbelief is a more cognitively effortful response that's prompted for some reason. So we get to this idea, what might interfere with disbelief? And this is something we can study in the laboratory. But basically what we see is if I'm not motivated to disbelieve it, if I'm just operating in life somewhat mindlessly, I'm low for need for cognition, that is, I don't like to think that much, all of these then make me really prone to just accepting what I'm told or accepting what I see and not questioning it, not going the extra yard and employing maybe some critical thinking. Now, okay, that's one concept, right? That belief is automatic, disbelief is effortful. Let's take another concept and we'll kind of look at how they work together. To combat mental contamination, let's suppose that I have information that somehow contaminates my judgment. Can I correct for it? So now notice this is what is the process I use to correct for the influence of unwanted, inappropriate, inaccurate information? Well, the first thing, I have to realize that an unwanted mental process was triggered, that I've consumed information that might bias me in a way that I care about. But if I'm not aware, if I never ever think about it or realize it, there will be no correction made. So let's go down this list, and if I complete all these steps successfully, I'm in a position of making a correction. But if any of these steps along the line are not realized, then in fact I won't make a correction. So, am I aware of the unwanted process? Am I aware? If so, okay. Next question, am I motivated to correct? I might be, wow, that's some biasing information, but I don't give a shit because I hate this son of a bitch, so if it biases me against him, who cares? Or am I the kind of person, wow, this piece of information might have biased me towards the defendant, and I want to be fair in my assessment, so I'm motivated to correct. So notice, the motivation becomes all critical here. Now, this one is an interesting one. Aware of, so I'm motivated to correct. Yeah, I want to correct for this. But how did the information bias me? Did it bias me for or against? And you're saying, well, duh. And it is duh. That one's pretty simple. It's pretty easy to figure out that this biased me for or it biased me against, right? Now, we've done a lot of research in our lab, in the Tetlock lab. What we would do is we would present people court cases. That's much of our research. We present people mock court cases and then ask for their punishment decisions. What we would do then is often manipulate the nature of the evidence, at least in our initial research. Later on, we used a lot of subliminal priming manipulations to see if we could affect motivations. But let's keep it simple. That is, we might present a piece of evidence in a certain experimental condition and that would bias somebody. And then they would determine the level of responsibility in the defendant, and they would assign punishment, and then they would continue in the experimental packet. They would turn to the next page, and we would say, oops, wait, there's a piece of information there that perhaps you shouldn't have received. And then we tell them what that piece of information is. So we say, now we want you to go back, reread the case, right, and factor out that piece of information and reassign punishment. So we could see how effective people were in actually changing on the basis of their perceived bias. Well, what we got is people could always correct properly. They always corrected in the right direction. But they never got the magnitude. They never applied the proper amount of correction. And obviously we have control conditions, so we know what the proper amount of correction is because we have people who never got that piece of information, right? So they are the corrected people, so to speak. So here's the lesson. People in our research always correct properly, that is in the proper direction, but never enough. So they failed in the magnitude portion. Now, if I am motivated and I'm aware and, got some kind of handle on the magnitude, am I able to adjust? And sometimes time pressure might prevent us, for example, from being able to adjust. Because this would apply, let's suppose you're interviewing job applicants. And there's something about applicant number 3 that inflexibly biases you against that applicant. Right? Maybe they resemble an ex-partner. Maybe they're from the University of Michigan. Whatever it is. And you say, oh my God, I'm biased towards this person. Right? And you say, okay, so what direction am I biased? How much should I correct my judgment? How much should I alter the score I'm giving them in their interview? And your boss calls you up, and while you're fussing with all this mental kind of labor, your boss says, you need to hire someone like 5 minutes ago. Get on it. And so the candidate that presented you the issue, they're just, let's forget that and go to a different candidate, right? That you might not have time to adjust. But if you're able to adjust, then you might supply the correction. Now, let's take a look at this. Straight up social psychology, social cognition. We tend to believe what we're told unless we expend the effort to disbelieve, and we'll only do so if we're motivated to do so. And even if we are motivated to do so, we might get the direction right, but we'll probably get the magnitude as being insufficient. That's the picture of, empirically supported picture of how people reason, especially within the punishment context or assigning blame context. What does Ohio say, though? Because remember, I'm talking empirical research. What does the law say? Because ultimately, it's what the law says that matters, right? So, criminal procedure rule number 9 says that a juror can be dismissed for cause if he's possessed of a state of mind evincing enmity or bias toward the defendant or the state. So either way, the state or the defendant, right? Because we want to give both a fair deal, so to speak. But they can't be dismissed by reason of a previously formed or expressed opinion with reference to the guilt or innocence of the accused. If the court is satisfied from the examination of the juror or from other evidence that will render an impartial verdict according to the law and the evidence submitted to the jury trial. So what basically, if we kind of, interpret this, social psychologists are saying, look, we can't do it, or we're not going to do it properly even if we're motivated to. The courts turn around and just say, hey, it's okay because people can do it. And of course, this is one place where I will argue strongly against the courts. Social psychologists have the empirical evidence. Courts have an opinion. So we have evidence against opinion, but in this case, obviously, it's the state, so the opinion is going to win. What are some potential remedies for pretrial publicity? Well, we can gain a continuance, and that means we can carry on the trial at a later date and maybe let the impact of the publicity diminish over time. And the Supreme Court favors this, but again, from a psychological point of view, what do we see? Well, as time goes on, we know that general memory effects, that memory decays over time. So if we offer a continuous, the memory for the factual evidence diminishes, but what we find is the emotional flavor and the emotional impact of the case doesn't necessarily diminish. So what we then see is the power of evidence diminishing and the accuracy of evidence diminishing over time, but the emotional flavor remaining essentially the same. So that's probably not a good thing for a fair trial, right? Now, we can expand the voir dire, and that is that we can try to increase the number of potential jurors from whom we're selecting and try and find people who haven't been exposed to the pretrial publicity. And the work of Nisbet and Wilson suggests this won't help because we're very bad at introspection and correction. So we're interviewing potential jurors and saying, hey, were you subjected to any publicity? And they said, yeah, I saw a little. And then we asked the question, well, do you think that that had in any way, shape, or form biased you against the state or biased you against? And people will say no because we don't understand how our own minds work to any great degree. So, other judicial instructions, please ignore anything you've heard or read in the papers. Not likely to work. We've seen a lot of studies that kind of support that's not going to work. We can instruct them to consider only evidence and not biases, but yeah, they may not recognize their own biases or they may not care, right? It's very difficult to suppress thoughts, and Wegner demonstrated this. Do we know the study I'm talking about? Dwayne Wegner? Let's try it out. This is catch-22 phenomenon. That's the colloquial expression. Ironic process control, which sounds much fancier, is the official term. And what if I told you for the next 15 seconds, I don't want you to think about Quincy for the next 15 seconds at all? And we know that when we try to suppress a thought, what happens is the psychological mechanism, and I said, don't think about that. So you've given your brain an instruction. You told your brain, hey, don't think about it. How does your brain know, though, that it's successfully following that instruction? Okay, so you told me not to think about Quincy. Am I doing that properly? Am I thinking about Quincy? Oh, shit. So every time you go to check to see that you're following the instruction, then it reminds you of what you're not supposed to be thinking about, and it brings it back to mind, and that's why they call it ironic process control. The more you try to control the process, the irony is, the less in control it is. Now, you can import jurors. That is, you can bring jurors from a whole other community that maybe weren't subjected to the publicity, but let's think about how expensive that is. Not unlikely to do, not likely to happen. And it resembles a change of venue where we move the trial to a new location, And that's what they did in Los Angeles with OJ. They took him out of the Los Angeles courts and they moved him to Santa Monica, which is a little enclave within inside Los Angeles. I don't know what that was supposed to accomplish. And the OJ case is a whole nother story. So it's very expensive and difficult to do. What do we know? We are done. So you got DB3, discussion board 3 embedded in here. And again, I hope that we've lived up to the promise of the dilemmas so far in this course. That easy answers are likely not present. And we're faced with dilemma after dilemma after dilemma. Okay? So I want you guys to have a great day. See ya.